I'm happy to present this presentation to you on custody issues when treating minors. The presentation will focus on issues related to treating minors with parents who are legally separated or divorced. Next slide. Hello, everyone. I'm Allison Funicelli. I am a senior risk management consultant in the risk management department for AWAC Services Company, a member company of Allied World. Next slide. So we're going to begin by talking about informed consent because that's one of the most common questions we get on our risk management psychology helpline as it relates to custody issues when treating minors. So first, let's consider informed consent. So as soon as you take on a new minor client who has legally separated or divorced parents, it's really important to get a copy of the custody agreement because it should spell out the specifics of who has the right to make medical decisions for the child. Now, I'm not going to get into all the various types of custody agreements. I'm going to touch upon like the three most popular. So one type is where one parent is granted full legal custody, okay? So that typically means that one parent makes all the decisions for the child. It doesn't mean that the other parent doesn't have visitation, etc., but if a court orders one parent to have full legal custody, not custodial, meaning that's where the child primarily lives, but full legal custody, that parent is usually in charge of all decisions, including medical, for that child. More commonly, you see joint custody. So that usually means that both parents have equal rights to make decisions for their child. And then you might have a hybrid, like in between, something where one parent is allowed to make certain decisions without the other parent's consent, but generally they have equal rights in other decision making. So that's why it's really important to get that custody agreement up front so that you can make sure you're following the agreement. And if both parents have joint decision making as relates to medical decisions, you need to make sure you get informed consent from both parents. And this is in a custody, divorce type situation, not if the parents are married. So again, make sure you get both parents' consent when you have a joint custody situation. If you get a copy of the custody agreement and you're not sure what it says or what you're supposed to do, then the best thing to do is contact either your personal attorney or your practice attorney, or consult with a risk management professional in the risk management department of your professional liability carrier. They can help you with looking at the agreement and figuring out who you need to get consent from and what the rules are that you need to follow. If only one parent has decision making, then you only have to get consent from that one parent. You also need to be familiar with your state statutes because in some states, children under the age of 18 have that right to consent to mental health treatment and make their own decisions. So regardless, in certain states, what the parents say, a child might be allowed to consent themselves. And if they do, just understand they may not be able to pay you, but they may be able to direct their own informed consent. If they are an older child, even if they have to be 18 or older to officially consent in your state, it's always good if you have an older teen to involve them in the informed consent process anyway. And then as far as guardian ad litems, so sometimes, especially in contentious divorce agreements, divorce situations, the court may decide that they're going to appoint a guardian to the child. So if a guardian ad litem, you'd have to ask the parents if one's involved, or it may be spelled out in the custody agreement. If a guardian is involved, you may need to get permission to treat or get informed consent from the guardian ad litem on behalf of the child as well. So it's important to know if a guardian is involved. And all this is important because you want to make sure you're protected, and you document all this as well in your chart so that if a parent becomes disgruntled, that if they bring a claim or a licensing board complaint, you have documented and you've gotten the agreement and you're following what the court has instructed. Now, certainly, usually the the custody agreements, even if it's joint custody, may say in emergency situations that a parent, in an emergency situation can make, a solo decision right in that moment. Next slide. So who has access to the child's records? So does the parent, if a parent's asking for their child's records, you need to confirm that they have the authority to get them. So again, that custody agreement may specifically spell out if a parent can have access to their child's records, but a lot of them don't get that specific. But if a parent has medical decision-making power and authority under the consent agreement, they probably also have the authority to get their minor's records. So that's important to know. The next thing is, does the child have the right to deny parental access? So again, there are situations where if a child under the age of 18 has rights regarding their mental health treatment and they can make decisions for themselves, they may have the right to deny that parent access. So again, you need to know from your own state statutes what they say. It's also important to determine whether or not releasing the records to that parent may be harmful to the client. So, for example, maybe it's a contentious divorce situation, the child may be talking about it in therapy and may say things about one or both of their parents, and you document that in the chart. So if you believe that there could be harm by releasing those records to the parent that's requesting, then again, I would consult an attorney or consult your risk management professionals so that this way you're following the rules and the laws about if you're going to withhold a record, right? Because you can't unreasonably withhold records, but you may have certain rights as the provider to protect the minor when releasing records. The next thing is, why does the parent want the records? Ask that before you release it. It may be, to get reimbursed through insurance or something, or it may be because now they've consulted with a psychiatrist and the child's going to take medications, So in that situation, you may say to the parent, well, fill out an authorization and I'll release the records directly to the other provider. This way it's protected under HIPAA. The parent may not be completely forthcoming with why they're asking. It could be because they're hoping that you've documented something that's going to be helpful in a contentious custody battle. But ask them why they want the records and document that. If they want the records and they say, it's because they're going to use them to their advantage in a custody agreement, you may want to say, can you have your attorney serve me with a subpoena or a court order for the records? The key here, and especially in contentious situations, is to be neutral, right? You don't want to get dragged into the parent's custody battle. So if you do release records to one parent or that parent's attorney, the best thing to do if in a joint custody situation is to release a courtesy copy to the other parent. So again, you're staying neutral, you're not showing favoritism from one parent to the other, and this way they both have copies of the same thing for whatever purposes they're going to use them. If you do receive a subpoena or court order for records or your appearance, because they want to subpoena you to drag you into their custody battle, immediately contact your professional liability carrier. They may have a provision under the policy that may assist you with speaking to an attorney to assist you. If not, then at least consult personal counsel. It's important that you make sure you comply with the subpoena or court order and that you take steps to protect yourself in those situations. Even if an attorney says that they're going, if one of the parents' attorneys may say, oh, it's all, going to be great and I'll help you out and, you're going to help us. But that attorney representing those parties are not necessarily friendly to you. So you want to make sure that you protect yourself and your rights. And again, stay neutral in that situation. Next slide. So what can we do to reduce liability? So you can reduce your potential liability when treating a minor of divorced or separated parents by, again, step one, getting that custody agreement. Once you have that and you know which parties you can speak to, especially when it's a joint custody situation, you want to come up with a consistent treatment plan. And if you need both parents' buy-ins, you need both their consent, then you're going to have to create a treatment plan that they both can get on board with and agree to. If one parent becomes uncooperative in their child's care and they have joint custody, you may recommend to the parent that is compliant that they may need to go back and seek legal assistance with they might need to get the court involved or something so that both parents get back on the same treatment plan agreement. Again, you need to stay neutral. If one parent is insisting on wanting to not comply with the recommended treatment plan or wants to have their child no longer see you, again, you may have to have a discussion with the complying parent and let them know that you're going to have to either suspend care while they work out the disagreement, and if it gets really contentious, you may have to terminate the relationship. It's unfortunate, and I know it can be sad, because you're trying to treat this child, especially if they're torn in a custody battle. But at the same time, you're going to have to follow what the custody agreement says. So if you need both parents to consent and one parent is no longer consenting, you're going to have to cease treatment until you can, the parents can get on board. Or, like I said, you may be in a really difficult situation and you may have to terminate care altogether. Again, in these difficult situations, it's best to consult a risk management professional or an attorney for assistance. They may be also able to assist you with any specific state requirements or statutes that apply to these situations for where you're practicing. Next slide. Privacy concerns. So again, there's an interconnectivity between privacy, confidentiality, consent. So it's important that you follow your state and federal requirements regarding HIPAA and privacy. So we know that there's a federal privacy statute called HIPAA, but states also have individual privacy statutes. So you have to follow whichever are the strictest. So if the federal HIPAA requirement is stricter, you have to follow that. If your state privacy requirements are stricter, you must follow those. It's important that for parents who have no authority to make medical decisions for their child or access their records, that they seek proper permission if they are asking for your records. So if, for example, dad has full legal custody and mom has no rights other than visitation or something like that, and they're trying to interfere with the child's care, you would need to instruct mom to go to dad, because that's what the custody agreement says you have to follow. And they'd have to get the information through dad. That might not make, in this particular scenario, mom happy. She might get an attorney, insist you give the records. Again, you want to consult counsel or consult your risk management professional to assist you. And you may have to say, serve me with a subpoena or get me a court order, and then you would report that to your professional liability carrier, who will help you further, so that this way you're not releasing information that the parent that's not entitled to it, so that they don't get it. So these custody situations can be very tricky. It can cause a lot of stress on the minor client. It can cause a lot of stress to you and your practice. It can cause a lot of stress to these parents. So, again, this is just a mini talk. I'm just doing a very high level discussion about custody. You can certainly contact your professional insurance carrier for more, detailed information. In order to, discuss your specific scenarios that you may have. Next slide. I want to thank you for listening to this mini talk. For those that are insured through the APA endorsed professional liability program with American Professional Agency, one of the benefits that's being offered by listening to this presentation is that you can get a risk management premium credit. Since this is a recorded program, we've added a keyword at the end of this session that for the Allied World and American Professional Agency insureds, to get their premium credit, you're going to need to document the keyword. If you attend all 4 of the different topics, you'll be eligible for 2 premium credits. If you attend 2 presentations on 2 different topics, you'll be eligible for 1 premium credit. Please record the words that we provide at the end of each of these presentations to the American Professional Agency after the conference is concluded to use towards your malpractice renewal or as a new policyholder. Any courses taken within the year prior to inception or renewal of a policy will be accepted. If you've already renewed your policy under this program, the credits can be applied to your next renewal. If you have any questions, please visit us at the American Professional Agency virtual booth, and either myself or my colleague will be happy to answer your risk management questions. The key word for today's session is agreement. Once you have all of the keywords from the presentations that you listen to, please send the keyword list to psychology@americanprofessional.com. Please include your name, contact information, and policy or account number. Next slide. This is our legal disclaimer. I'm not going to read the whole thing, but for the sake for the sake of time, I'm just going to point out that this material is provided as a resource for informational purposes only. It's not intended as, nor does it constitute legal, technical, or other professional advice or recommendations. Please consult your professional advisors or legal counsel for guidance on issues specific to you. No responsibility is assumed to update this material, and there is no guarantee or representation that this information will fulfill your specific needs or obligations. This material may not be reproduced or distributed without the express written permission of Allied World Assurance Company Holdings, a Fairfax company. Next slide. Allied World policyholders may contact the Risk Management Department at 860-284-1305, or you can email us at riskmanagement@awacservices.com. Next slide. For your insurance needs, please contact the APA-endorsed Professional Liability Program American Professional Agency at 800-421-6694 or at psychology@americanprofessional.com. And again, that keyword for this presentation is the word agreement. Thank you.